What is a living will, and why should people be interested in having one?
Sure. So a living will is really known colloquially as the pull the plug document, but it's actually a document where you declare whether you want to be withheld from life-sustaining medical intervention. So what you need to do to have that document be a legal document is you need to sign it before two witnesses, and you select whether you want nutrition and hydration or whether you don't want nutrition and hydration.
Okay, so just in front of two witnesses, or do you need a notary, or you can do it both ways? What do you
Well,
mean?
the great thing about the living will is that it doesn't need to be signed before notary public, but the two witnesses can't be related to you by blood or marriage, and they also can't be anyone who would inherit from the person who's signing the living will under that person's own will.
Okay, so just to make sure we're keeping up, and I'm keeping up, typically this applies not only to the person who's lived to the ripe old age of 90 or 100 or 80 years old. This applies to the person who maybe has been in a terrible car accident, or they have some illness that afflicted them maybe when they're too young. They could be at any point in your life. Lord knows when your ticket is called. A living will is a document that at the Sessions firm, it's recommended people have this so your wishes can be honored.
Exactly. So we have, whenever a client comes in for a regular estate planning, which would include a will and a power of attorney, we always have our clients execute living wills, and most of the clients are happy about that. But if you truly don't care whether the plug is pulled or whether whether somebody else makes that decision for you, then there's no requirement that you execute a living will. But it certainly is important if you want to make a medical decision for yourself and you're not going to be able to make that decision at the time.
Okay, so if you don't have a living will and you're in that hospital bed, and let's say the doctors say that you're brain dead, if you don't have a living will, who gets to decide whether or not to pull the plug or keep you on life support for an indefinite period of time?
Well, the law is very specific about the order of who would make that decision, and obviously the first person in line would be yourself if you're able to make the decision, but we're talking about a situation where you won't be able to. So
that means if you're the patient and
right,
you're incapacitated
exactly.
in bed, and you've had maybe a terrible brain injury or the cancer or whatever it is that got you in that bed,
right,
you can't make those
right.
decisions.
So you can't make this decision. So the next person in line would be your curator if you've been interdicted, or your tutor.
All right, so let's say that in plain English.
Sure. So if you've had somebody appointed by the court to make decisions on your behalf, then that person would be considered your curator,
Okay.
and that person would make the decision. And then the next person in line, if you haven't been interdicted and you don't have a curator, would be somebody who you've named in a medical power of attorney to make that decision for you.
And if you haven't done a medical power of attorney to make those decisions,
Then the next person is your spouse. But I think what's interesting about that is that if you do name somebody in a medical power of attorney, that person trumps your spouse. And then if you don't have a spouse, then the next person in line would be an adult child or children.
you could name your spouse in a medical power of attorney?
You could name your spouse in a medical power of attorney. You could name a close friend. You could name your accountant. You could name your lawyer. You can name a physician. You can really name anyone who you want to.
Okay.